land reform, land management, land acquisition. Now we are shifting this session to the adjudication. You have a law, but and then you have a dispute, and dispute is not only between the state and individual, but there are disputes among the citizens. And what happens when people use the court. So we have a first speaker, Ms. Astha Saxena, in the panel. And Astha would present some live case studies on the kind of issues they have compiled, the case studies they have compiled, and the challenges the case facing in the court.
Thank you very much, Justice Malla. So after we had that raising discussion about redistribution, just before I start anything, I just want to quickly respond to Professor Bakshi's comment, which he made on conceptual misplacement of our study. The only little point that I would like to make there, sir, is that before we begin to talk about a right to land or rights to land or right to property, whatever it is that you want to call it, we had to take a step back to just know what the law was. And only when we were aware of a terrain, of the web of laws that I have been walking on for the past 2 years, maybe now we can talk, from here we can talk about the right to land as a conceptual topic at all. Right now, all I have for you is how law is, what is the nature of the law, and how do we litigate. So the first part was how the law was, and the second part right now is, we call the panel called Contesting Land in the Complex World of Property. So when I first began, I spoke about two sorts of land relations that the law regulates. The first was between the state and an individual, and the second was between individuals. So this part of the presentation would just talk about how individuals contest land in courts. Mostly. And because land is contested as property, it brings out an entire dangerous era of events that the litigants then have to fight for about 10, 20, 30 years ongoing land litigations that we have. So these complicated land relationship between individuals, their socio-economic aspects, which we do not consider in law, and we conceive them as property, and where the right to property was a class affair. It was only available to people who had the land, as we have spoken about in the past, in the previous panel. And we say that the second part, the other classes who were to receive land, did not have any right to property as such. So the conversion of this land to property, when it comes in law, it becomes deeply problematic. When you don't understand, I think neither does law understand the property concept. We in India, at least, we don't have one solid property concept. We take from various theorists on the issue, and we apply what is convenient to us for us to do. And neither do we, as law people, understand land. And because we don't understand either, we land up into this muddle. We call it a complex world of property because immediately when you see land as property, you allow only one claim to happen at one point of time. There is the idea that multiple claims can coexist on land, on one single parcel of land, becomes diminished when you say that only one, either if it is right to ownership or possession or mortgage or whatever it is, if you're only talking in terms of one single agenda or one single right, which is only exclusionary in nature, essentially. You say, this is my land and hence you cannot enter it. The moment you do that, the moment that translation happens from actual land to legal property, there is law creates, I think, a circus of its own. You know, we like to litigate it a lot. and then we keep litigating it until, well, there is no solution. So as a group, we had these 8 case studies, which mostly happened in the lower Karnataka judiciary and Karnataka High Court, where we studied every land litigation from scratch. So from the first time that a claimant goes to court, seeking for a permanent injunction or anything else that he's claiming his right for, or for a right to tenancy, or against eviction, till the time, if there is any end to that litigation, from wherever, whatever was the latest update on that litigation. So we have these 8 rigorous, huge case studies, out of which I would only be doing 2 here, because we don't have the time to do all 8. I have 10 more minutes, as my timekeeper very nicely tells me. So I'll give 5 minutes each to both the cases. The entire idea is to demonstrate how difficult or how dangerous can just the property jurisprudence be for land when it is litigated in courts. So the first case is of one Padma versus Krishnappa. So according to the land reform, the Karnataka Land Reform Act, there was a Wellesley Missionary Society which had about 17 odd acres of land, and it was redistributed to its tenants for about 1 acre each. So Padma's husband got about 1.5 acres in that redistribution. And after his death, according to all the land records that were present at that point, the transfer happened from Padma's husband to her. So all the revenue records, after the 4D proceedings, 4D proceedings are when you subdivide land. If you subdivide a large piece of land and you say that one belongs to these various persons, they call it 4D in Karnataka. So after the 4D proceedings, Padma was allotted her serial number. The original serial number was 46. She was giving after her husband's death, she inherited serial number 46 by P2. Now, Padma, she has all the papers to her name. She has the tenancy certificate, the occupancy tenancy certificate, which originally got her to get land. And in all of it, their boundaries are clearly marked. So we have who's on the left, who's on the right, on the northern, eastern, Sadama's dispute, saying that yes, she is the owner and the possessor of land, and because permanent injunction depends on your possession rather than your ownership, and you seem to have possessed land, you seem to have all this boundary disputes and boundary certificates and everything. Only one anomaly in the land records the judge decides to oversee. So when the tax receipts of all the 4D of all the revenue records were there, in one of the years, instead of saying 46 by P2, the record said 46 by P1, which happens to be Krishnappa's property. Now, the court decides to say that this is only an anomaly, and of course, you have to give some amount of man or woman making dispute. Sorry, I lost track there. Yeah, the human errors. Thank you. So you have to give it, and let's move ahead. This is too much. Padma, okay, you have the land. Here is your decree of permanent injunction. The same judge, after the subsequent year, gives the same permanent injunction decree to Krishnappa on the same grounds. Says that, well, you seem to have 46 by P1. Your boundaries are also well determined by your compromise degree, which incidentally you have, the basis of that compromise decree is not under contestation in the court. So the court takes that compromise decree as it is and says that, okay, so there are these two same judge doing this, giving that permanent injunction decree to two contesting claimants, and of course there was further appeal, and these two cases are running simultaneously. When both of them go into appeal, the sitting judge in Karnataka High Court, after the second appeal that goes up, says that I'm not sure whether your lands are same. They might be different, but we will have to go back to the evidence that was given in the lower courts to see whether your lands are the same at all or not. Or whether they are different, we don't know. We can't do it. And hence, the latest update that we have in that case, that both the permanent injunctions were taken back and the case is under stay. Now, second case was Timaya versus Kalatti Timaya. This is again a land reform originated dispute, saying that in this case, what happened, that there was redistribution by the collector of a large parcel of forest land that was cleared. And then in 1993, after that redistribution happened, through a subsequent court decree, that allocation of land was declared to be invalid. It was said that that allocation was not done as per law, and the collector did not have the requisite power or the authority to do so many things. However, this declaration happened 5 years later, after the redistribution was done. So for 5 years, these claimants who had received this redistributed land were enjoying the land until this decree came. Now, after this decree came, 10 years again later, Timaya decides, there are concurrent land administration proceedings happening, and the Karnataka land administration decides that since that land redistribution was not fairly done or validly done, let us do it again. Now, because you have to do it again, and they redistributed the same parcel of land without giving any sort of notification to the previous receivers of land. So here is Timaya 10 years later, after he realizes that his land was previously redistributed to someone else, and he does not know what to do. So, of course, he files a suit and says, because mine is the latest allocation, I should be given. And it's again a suit for permanent injunction. The possession, the court is unable to determine who has the possession, because every evidence that you put in court for land has to be on paper. So if you are saying that a tenancy certificate is possibly your evidence of possession, how do you say that if land records of several years are stating otherwise, and that is again an evidence of possession under the law? So you have these contesting, not only claims, but these contesting evidence, which are possibly conflicting in very many varieties, because the court cannot decide which one to prioritize over the other. If you have one anomaly in one revenue record, it seems all right. If every evidence is stating otherwise, it seems all right to say that it might have been a stray entry. But then to later say that, well, we are not sure whether the land is the same. Your southern boundary is possibly the same, it's BH Road, but what happens, we are not sure whether your other boundaries are matching or not. We'll have to go back. Similarly, in Timaya's case, it's a very long litigation. It went, okay, my time's up. It's a very long litigation. It went for about 25 years, and I think it is still going. But I think questions of evidence, questions of what is the law on permanent injunctions? How are you saying that possession can be proved by paper in court? And how are you establishing connections between the law? If, for example, that compromise decree that I was talking about initially, if the validity of that compromise decree is to be challenged, there is a direct connection that then the law has to make between family law and land law. And that I don't think we do very much. Thank you.
Thank you, Astha. With your case study presentation, you have raised many issues. One is, of course, how the conflict is created with the administrative decision, but also you have connected with the problem within the court recording system or filing system, and how judges is giving injunction to both the parties in the same case. But still, I mean, you said, is it it's the same land or not? But yes, there is a problem. And you also raised the question of time that consumes in the adjudication process, and it goes generation to generation. And you have also highlighted that, yes, there is a need to connect land law with other related legislation. For example, you brought the example of family law. So in your presentation, you did mention that the documentation process is a problem, and we have other speaker, Professor Ayaf Faizi, who is a scholar on the modernization of land records, who will elaborate on the nature of land disputes and how the modernization of records would help in minimizing certain nature of disputes. Faiza, now floor is yours.
Assalamu alaikum. Peace be upon all of you, and good afternoon. I must thank to Professor Faizan Mustafa and Professor Amita Dhand and all her team for inviting me and giving us such a good hospitality, and giving an opportunity to attending and learning in this wonderful August gathering. I must congratulate Astha for her great job, a great study, and she very cleverly related this land to socio-economic status. It was related from the ancient time. The lands was so important in the life of every human being that everything was out of that land. Either it's social status, economic status, political status, culture, religion, everything is related to this one. And whenever we will dealing to this socio-economic status to land, it will be, we will land at nowhere place. So it is a very important thing, important aspect of the socio-economic, when we will go for the socio-economic status study. I have been asked to go for the this is what is land record? During the last two case studies, we were looking that there were so many of documents whom we call the land records. What are those documents? So, and what we want in land records? what are the information we are looking for in the land records. It must be the geography, where is the plot, where is the two-dimensional or three-dimensional piece of land is there, who is the owner and title of the land, and the use it is being put to. It is the agricultural land or whatever it is being. The land rights, it's also mentioned, customary rights and all that, tenancy rights, including details of minerals, water, and other resources are pertinent to it. So a lot of information we are looking for in the land records. This is a very rough thing that we can classify in any manner. But we would try to classify in primary or subsidiary records, or permanent and temporary records, or survey and settlement records and subsequent updation. These are the things that if you have a document, a registered deed, is it the final document that proves that you are the owner? No. You have to go back for the survey and settlement records. Survey and settlement records having all the information and data? No. So there is some sort of primary or permanent records, and then you find some subsidiary and other resources to complement it, to supplement it for the making the records updated. So these are the issues I would like to discuss. There are another kind of classification we may do it, that is the spatial and textual. Spatial means we have the maps. Maps is basically being created by Survey and Settlement Department. And then the textual. Textual also contains the data, geographical details of the land, information about owner, information regarding tenants, information regarding crops, and a lot, whatever the information. Even you want to have the caste certificate, it is being taken from the land records, which caste you belong to. So land records gives a lot of information, and the land is a state subject. And not only that, the state-specific legislation is there, but it varies from district to district in some of these states. So there is a variation across the states and within the states also. And there is a variation that there are areas where we don't have any records, like in Northeast, and we have area where we have a very good form of very good status of the land records, like in Haryana or in some parts of the Karnataka and all that. There are some areas which is called unsurveyed areas, permanently settled areas, areas under customary community usages. So there are variations in the records, in the status of the land records, how it is being created, how it is being developed, and what kind of records we are having. It has some sort of lineage from the history. There are mainly three kind of settlements: permanent settlements, Mahalwari settlement, Rayatwari settlements, and besides that there are several others in tribal areas and all that, and all have their own culture, their own design, their own forms and formats of the land records. So it varies from area to area. One of the important challenge of the land record is that it is being dealt by many agencies. We have the Revenue Department. In many, there may be different nomenclature in different states. In some of the states, it's called Land Reform Department, and my colleague says that it is a misnomer. It It is not a land reform department, maybe land resources department or any other. So there are department, namely dealing with the land revenue. The other is the survey and settlement department, and the other is registration. There are these three are the major department in most of these states. Maybe some more department which is dealing with the land records issues, but these are the three, and there is no linkages between these three departments, and it is one of the major challenge how we will go further on integrating and updating of the land records. And these records should be updated and corrected to reflect the true picture of the day. And it is an issue that when we are going for the computerization of land record, we did it in 2 or 3 years or 3 years or 4 years. And when we complete the computerization of all the textual land records or special land records, by that time, 20% or 30% records has already been changed. So the whole exercise, once again, we will have to put. So there should be some system that there must be a single server or single window or single mechanism where any changes have had to be reported and automatically being updated. So this is one of the issue. The second is the physical storage and maintenance. We know that at the village level, we have a village patwari or karmchari, or there are different nomenclature for the village level revenue officer, and he is very important, very, very important. He maintains almost 20 odd registers which related to the land records, including Khata, Khatiyan, Khasra, Girdavari, and Chitta, Kacha Chitta, a number of, and he is very important. And we know that his office is in what stage? All in most of these districts and villages, they carry the whole luggage of records on his bicycle or in his house or somewhere else, in which it is in a very, very precarious condition. I just, a story is coming into my mind, I want to share it. Mr. Qudratullah Shahab was 1942 batch ICS officer and was principal secretary to 4 or 5 president of Pakistan. He wrote in his autobiography that once President Ayub Khan's mother wrote to her son when he was president that my patwari is not listening to me and not updating my land records. And he has to come to Patwari to request, please do this thing. So the Patwari was so important, and is so important even today, that because as Astha rightly told, that the information of the land record has not been delineated to the lowest stage. So the information about the land records, how it is maintained, how it is being, and what is there. So it is very important that the information regarding what is the land record and what is the right of the landowner or tenant or whatever it has to be, it should be disseminated to the every person. I'm skipping one or two things, coming to one of the important point at the end, that we have to go. We are in at the present stage, in the presentive stage of presentive system of titling. In this presumptive titling system, as the case study shows, that one has to prove that I am the owner of the land by 12 or more than a dozen of documents. And then when he proves in a court, another C person comes and that again he have to prove against the C person that I am the owner. I am the owner of the land. So how long it will go? We will have to go for the conclusive land titling, that a piece of paper, A4 size paper, will prove that I am the owner and I have the rights. Whatever the rights I am deriving from that, it is my own. And for this purpose, at least three things has to be done. One is there should be a single window. That means there should be a single server where every updation, either it's through registered deed or through partition or through heirship or any reason, if there is any change in the land records, it has to be updated in all the records. It should be automatic and it should not be manual system. Number one. Number two, it should be there should be a mirror. The document should show the present status of the land, the current status. It is not that half of the information is being given and half is being supplemented by other documents. And the third is there should be a curtain, that today we will have to produce the chain of the document that proves that it is your own land. So these three things, when you will prove, then only it can be ensured that there is a conclusive land titling system. And conclusive land titling system is important for the poor more than the rich, because rich can fight in the court, poor has had to be. Thank you very much. I think I am on the time.
Thank you, Professor Faiza. You have clearly presented how dispute can arise when there is no proper recording system, and one of the reasons which you have indicated, when you have multiple agencies are responsible in registration, and when there is no integrated approach within the agency who are responsible, you cannot produce proper or adequate evidences, and when there is some changes is taking place, that is also not integrated among those agencies, and therefore you have recommended one solution could be a single window system. So thank you for your presentation. Now we have other panelist, Ms. Sudha Bharadwaj. She's a practicing advocate dealing with all these disputes. She's going to share us the kind of issues she's confronting, and she's trying to bring insights on how the issues are addressed in settling the disputes.
Yes, I am dealing with adjudication, but maybe the introduction that you gave, that it is regarding disputes between individuals, that is not really the case. I belong to a group of lawyers called Janhit. Mostly we do group legal aid, and mostly they are land cases, but they are usually the cases of communities and not really individuals. So with that little bit of so maybe I should have been in the other panel and not in this one, but I hope you will still excuse me if I go into those issues, because those are the issues that I deal with. The first thing that I want to say is that is the land grab, I can say, or for want of any polite word for it, which is happening in the context of mining. Now, because that is a place where there is a lot of confusion about the law which is happening. And if we look at the forested areas and the tribal areas and the mineral-rich areas, of course, you draw maps and they overlap one on the other. So now we are getting to a situation where in these areas there is an enormous crisis. We have already, in the presentation of Mr. Fernandez, we've already seen how in the 70s and 80s in the big development projects, actually far more tribals were displaced than they were a proportion of population. And actually what kept on happening was they kept on receding backwards and backwards into the forest. That's why if you notice where tribal people are, they're mostly on the borders of states, they're on the cusps between states, they're at the edge. In Chhattisgarh, we have them all around, and in the middle there's a plain area where you have no tribal people. Your Borivilis and Kandivilis were all tribal areas until people receded back to Thane, Dahanu and all that. So basically they've receded and now they have their backs to the wall. There is nowhere more to recede to. So I think now the time has come when we have to really think what is going to happen in these areas. Now, the first thing I'd like to say is, one of the acts which under 213 has been put in the schedule of the exempted acts is the Coal Bearing Areas Acquisition Act, 1957. Now, if we look at the entire North Chhattisgarh, that is Korba, Raigad, Sarguja, etc., it is the Coal Bearing Acquisition Act which applies here. We have done many, many cases about this. Now, that act, because the acquisition, first of all, you have the major minerals, and you say, okay, the state has all powers over these minerals. Once it is declared that there exists coal here, then it is automatically the eminent domain of the state. The state has all the powers to take it. And in the Coal Acquisition Act, even the little semblance which was there in 1894 Act that you could object to the public purpose is not there in the Coal Bearing Areas Act. So actually in the Coal Bearing Areas Act, all you can really dispute is compensation and rehabilitation. Now, even in the Coal Bearing Areas Act, initially when land was being acquired, at least in Chhattisgarh what we observed, even if a very small piece of land was acquired, permanent jobs would be given in place of that. And that was one reason why there was less resistance to begin with, because you actually created a lot of permanent jobs in the Coal India and all its subsidiaries. In our area, it is Southeastern Coalfields Limited. Similarly everywhere. But now with the efforts of the Coal India to contractualize employment, they are not interested in giving permanent jobs. That means they do not want to rehabilitate you, they only want to compensate you. And the strange thing is that sometimes the acquisition has happened 30 years ago under a different policy, where they forced you to take less compensation because you are expecting a job. And today they're saying now our policy has changed, we no longer give you jobs. So you take the compensation there and the job here. So you're mixing up two policies. You are not even going by what you promised. There should be some legitimate expectation or promissory estoppel, which all the companies rush to the courts and get orders about. But the people whose lands are being acquired decades ago are not getting this. So this is a serious problem. There is no system of prior informed consent in these areas where lands are being taken. A very, very strange thing has happened in the Chhattisgarh High Court, which is that a division bench has actually held that under the Coal Bearing Areas Acquisition Act, you don't have to abide by the PISA Act and the FRA. So, PISA Act is not applicable, Forest Rights Act. There was actually a PIL where people went to say that, look, we have not, the PISA Act has not been implemented, the Forest Rights Act has not been implemented, so please tell us who is going to do it. Is it the Coal India, is it the collector? Please tell us which are the authorities. And the reply to this was that you don't need to do it. So, and a very fallacious argument that 1957 Act is of the Coal Bearing Areas Act, and in the 1996 PISA Act, the state is prevented from making law. Actually, what is being said really is that with respect to the scheduled areas, only the center can make, or the parliament can make laws, state governments cannot make laws. So that has been interpreted to say you cannot make a law to help the people. And so, basically, and this is what we are contesting now in a review petition, and you can imagine the impact this is going to have when 61%, I mean, more than 60% of the area in Chhattisgarh is scheduled area, and, and without PISA Act, what is that going to mean? That's a very serious issue. Now, the other thing that I would like you to understand is that this was regarding mining by the public sector, but there's been a lot of mining by the private sector, by Jindal and so on and so forth. And in fact, most of the, a lot of North Chhattisgarh today, Adani is doing mining there. How does that work? Now, actually, that should have worked under the Mines and Minerals Development and Regulation Acts and the Mineral Concession Rules, etc. And actually, if you look at how mining leases are supposed to be given to private entities, it very specifically states, if you do not have surface rights, have you obtained the consent of the owner and occupier in writing? I would suggest to any of you to file RTI applications for the mining, for the applications made for mining leases by these companies. You will find that that area is left blank. Either they say will be obtained as and when required, or they say will be obtained later, or they simply leave it blank. And actually what the state is doing is, on that incomplete application, it is giving leases, mining leases to private companies. And once the lease is given, then of course the subdivisional magistrate takes out a notice saying, okay, you, ABCD, all of you, your lands fall in this lease, please come and collect your compensation as per the Land Acquisition Act. So people think it's a fait accompli, my land has been acquired. It has not. Actually, if you do not consent to it, they cannot enter your land. That is the law as it exists today. But lots of things have been happening in between. When we were all being very happy that the Supreme Court has cancelled coal blocks, saying no largesse, and decided that auctions are a fairer way to do it, then you look, tucked away in that Coal Mines Provisions Act is the fact that private companies can also use Coal Bearing Areas Act Acquisition Act 1957. So basically now the privileges which were there with the public sector are now going to be there with the private sector as well. The whole issue of consent has been thrown out of the window. Not only this, more dangerous, iron ore, bauxite, limestone, major minerals in all these areas, they are all going to go for auction. And when they go for auction, you don't go by the old laws regarding the leases, where, for example, there were many conditions in those leases. A private company could not have more than a certain area. You were supposed to inform whether you have already abided by, given adequate royalty, etc., etc., and only then you could get fresh leases. So all that is now going to go. So we are heading for a very, very dangerous time with regard to mining and with regard to tribal people. Now, the other thing that I'd like to say is that when you talk about acquisition for mining, or then it is assumed that people already have land rights. But actually we are talking about communities which do not have rights. We are only now recognizing that they need to have rights. Okay? So many years after, you had the 5th schedule right in the beginning. Once the Forest Act came and the tribals put up enormous resistance, the British realized that they are ungovernable, and they made you partially excluded and excluded areas. Even that, those have not been completely converted into 5th schedule and 6th schedule areas. In fact, there are many estimates which say that only about 1/3 of the tribals actually got recognized either as scheduled tribes, and many of the scheduled areas, for example, Sonbhadra in Uttar Pradesh was an excluded area. It is not a scheduled area. There is no scheduled area in West Bengal. There is no scheduled area. There are many states which have no scheduled area. So we already have left out a lot of people. We have left out a lot of people who are still claiming that they should be scheduled tribes, but they're not being declared so. So now the difficult task comes that when you're trying to implement the PISA Act, then actually what happens? Now the PISA Act is a very powerful piece of legislation. It came in 1996. It's a very short legislation, but basically it is talking about self-governance again, though again you're leaving out major minerals, you've only got minor minerals, you've many things you've left out, there are some ambiguities, but yet that is a powerful legislation. But actually, is there a political will to allow those Gram Sabhas to take decisions? No. That is the unfortunate thing. Most of the time in Chhattisgarh, we are challenging Gram Sabhas which have been done by fraud, by coercion, at gunpoint, for example, in Tata, Lohenduguda in Bastar, or in Bhansi and Dhurli for SR and Tata, or many other places. There is most of the time, fraudulent Gram Sabha resolutions would be found, concocted by companies on paper, or else they will get Gram Panchayat permission but not Gram Sabha permission, which is a very different cup of tea, because you have to consult. Or they make use of loopholes in the quorum to just manage some kind of a consent. The other, for example, I'll give you a very interesting case that we had done of a village called Premnagar. They 11 or 12 times convened Gram Sabhas and refused to have a plant because there was a private power plant to come up. They were overnight turned into a Nagar Panchayat from a Gram Panchayat. So, in fact, Aman Sethi had written a beautiful piece in the Hindu saying, if the villagers don't go to the town comes to the village. So whether you like it or not, you have been developed and made into a town, so that you no longer have your Gram Sabha. Now, this is actually totally in violation of PISA, which says you should take care to see that the higher levels of the panchayats don't usurp the powers of the Gram Sabha. Forest Rights Act, the same problem. Again, we are supposed to give centrality to the Gram Sabha. And it begins right in the beginning. You're beginning with the issue of first recognizing that villages exist. In the Raughat area, where the Raughat mining lease is coming up, the Steel Authority, etc., just simply said that there are no villages here. But they are. There were 11 villages, and there were 2 villages which were forcibly evicted by the CRPF. Now, obviously, when it comes to areas like Bastar, and the figures are something like there are about 6,000 hectares of mining lease which have already been granted for iron ore, which you can't mine. About more than half of them you can't mine because of the presence of Naxalites. And plus, then you have iron ore, and you have bauxite, and you have diamonds, and you have uranium. So you just can't leave it, let it go. And that is why you have numbers like the proportion to 1 lakh of population of security forces in Bastar is 1,770, as opposed to 800 in Kashmir and 139 all over India. So you just see the intensity of security forces which are there. I will just quickly conclude. Another thing which, anyway, this was basically about tribal rights and the question of first recognizing the rights. I think one major problem which the courts are having is in interpreting the Forest Rights Act, they are acting as if rights have been given to the Adivasis. No, the Forest Rights Act says we are recognizing rights you already had. We are admitting that a historic injustice has been done to you. You've been there for generations. We are only saying we are recognizing and vesting those rights, and that's all. The last thing I'd like to say is, it would be very nice if in your project you had also included the fact the 213 Act came up basically because there were many movements all over this country. And the issue of urgency clause, the issue, Narmada Bachao raised the issues of rehabilitation, settlement, planning of land, and so on and so forth. The ordinance was defeated not because of Parliament, because the numbers were enough to pass the ordinance. It was really the movement. And we have to see with concern the fact that states like Gujarat have passed Amendment Act cutting and pasting the ordinance. Though the Home Ministry has told them that it should not be forwarded to the President, it has gone to the President and received assent. How can you receive assent on a state law displacing a central law which is not in furtherance of the aims and objects of the central law? It is in fact with the purpose of diluting the central law. All these things need to be challenged and looked at. Thank you.
Thank you, Sudha. Thank you for focusing not only on individual claim, but group's claim, and but you have shared like what you have been confronting even in recognizing the right and Also, you said, like, although there are certain legislation like PISA which has come, but enforcement is in a problem, and there is no recognition from the court of historical exclusion in claiming certain rights. Now we have another practicing advocate, Ms. Vasudha Nagaraj. She is also going to share her experience in dealing with land-related disputes.
Astha, like Sudha Bharadwaj said, you referred to litigation, private property litigation. So Sudha Bharadwaj was speaking about land acquisition law and all that. Even I would be, in fact, speaking about litigation between the state and the citizen in respect of property. So I rarely go to the civil courts. I am appearing only in the high courts, because I feel that the most intelligent litigant, especially the non-tribal litigant or the landowner, rarely goes to the civil court. He comes to the high court, because getting a stay order in the high court is far easier and far more effective for this non-tribal or the landowner litigant than going to the civil court. And there is more power to a stay that is obtained in the high court. So this especially is in respect of cases of beneficial land legislations, like what we were discussing in the morning about the land ceiling regulations, where lands are taken, seized from the landlords, and these lands are then given to the Dalits and tribals. Or be it the land transfer regulation, which I will come to later. But first I want to take an example of the land ceiling regulation. Now, on paper itself, the land ceiling regulation is very dismal. And actually, when you come to the courts and see how much of this land that has been actually taken or surrendered by the landlords and given to the Dalits and tribals, it is really dismal. I'll just tell you one example in this. Land is taken from the landlord, and it's supposed to be given to 25 Dalits. Often what happens is that a survey number where that Dalit has to be given the land will not be specified. On paper, land is taken from the landlord and given to the beneficiary, the tribal or the Dalit. But the survey number will be so ambiguous that there will be no boundaries to it. There will be no description of that land where he is given. And this Dalit or tribal will be running around the revenue offices trying to see where his land has been given. On paper, in fact, much of our statistics will also include this kind of land, where on paper you have land has been transferred to the Dalit or the tribal. Now, this Dalit or the tribal sometimes is in possession, sometimes is not in possession. It's a messy kind of a situation. And often the landlord who has surrendered his lands only on paper. The kind of hold he has over these lands is truly amazing. Okay, now the next part of the story is, where, see, the poor Dalit and the tribal, unlike any one of us here, knows how to persistently knock at the doors of the MRO's office. None of us can ever knock at the doors of the MRO's office like the way the Dalit or the tribal can do. So he knocks and knocks and knocks. And then maybe after 10 years or so, finally the MRO, the Tahsildar will come and say, yes, these are your boundaries, north, south, east, west, and all that. These are your boundaries, and this is the extent of your land. Now what happens? Immediately the landlord or the landlord rushes to the High Court and says that this Tahsildar, when he visited the land and fixed the boundaries, I was not put on notice. Principles of natural justice. The principles of natural justice has been violated. Dr. B.R. Ambedkar would have would have really been shocked at the way due process and principles of natural justice is used by the high and mighty in this country, especially the landlord or the employer. So the High Court often doesn't even insist that the person who is in possession, who has actually sought for the MRO to come and fix the boundaries, should even be made a party. Behind his back, the High Court will grant an interim order. And now, due to pendency of work in the High Court, no judges, NJAC, collegium, that, this, in all this, for the next 15 years, the landlord will have this stay, interim order. And he will have the entitlement to the land. So getting an interim order vacated and saying that, yes, principles of natural justice was not violated. Indeed, there was a notice that was dispatched to the landlord, something like that. It's next to impossible for the Dalit litigant to litigate, because going to the High Court, getting your lawyers is not easy at all. Now, that is one instance, land ceiling regulation. Now, the second thing is, like, in our state, we have a lot of land transfer regulation, and we have a lot of scheduled areas, a lot of forest areas we have. Now, in these scheduled areas also, land transfer regulation, that any land transfer that has been made after 1970 between a tribal or a non-tribal is void. A tribal cannot transfer a land to a non-tribal. And here you should see there is all these perfect legislations on paper, but one has to see how the MROs and the registrars will try to subvert it on the ground. One is, again, boundaries will not be fixed. Two, about the kind of transactions that will take in the registrar's office. How land records are predated. All this messes keeps going on. Now, finally, this tribal here, tribal goes and knocks at the doors of the special deputy collector, who is the authority to hear these cases in the tribal areas. He says, I have been in possession, my dada, pardada, everybody was in possession here. There was this particular land transaction which is not the correct one. I have not sold the land to the non-tribal, and all this will happen. So with great difficulty, first time he may have, the tribal may not succeed. Second time he may not succeed. Third time, finally, somehow he gets a land document which says that this transaction was made after 1970, let us say. So he gets an order from in fact, he doesn't even get an order. He simply files a case there. He files a case there, maybe the third time. And that is when the non-tribal immediately will come to the High Court. Come to the High Court and say, sir, this is res judicata. Thrice the tribal has come before this court. Twice the special deputy collector has dismissed his claim. How can he come? Res judicata is such a central principle of the law. I cannot be made to litigate like this time and again. And then the High Court, and I'm not even speaking about ordinary magistrate courts or sessions courts or junior civil judges, no, the High Court, constitutional courts, they will not even insist that the tribal is made a party, and they will pass an interim order. So much so that the case which is presented before the authority gets stayed. And again, 10 years, 15 years for the order to be vacated. So in all this, what I keep, and this is something which tribal rights lawyers have been saying for a very long time is, or even lawyers working with beneficial land legislations, what they've been saying for very long is that at least, high courts should be careful when they are dealing with these kind of cases arising from beneficial land legislations. You cannot treat this property like private property. Just because the non-tribe or the landlord comes up and says, I have a title, you cannot grant a stay without hearing the other side. And it's not so difficult to hear the other side. Their notice can be issued and their counter can be granted. You need not grant a stay right at the very beginning. So the principle is that when it comes to beneficial land legislations, and when it comes to Dalits and tribals who have been put in possession and given pattas in such kinds of lands, there's something which the High Court should be following. And this is not something very difficult for the High Court. So I was thinking that if at all there are some recommendations from this study which can be submitted, you all do so many sessions with judges and all that. This is something which has to be conveyed to the High Court, that you can't give stay orders like this. Don't treat this like private property. This is beneficial land legislation. So if that thing can be conveyed, at least all those cases where Dalits and tribals are coming to the High Court will be saved of considerable time and expense in these proceedings. Thank you. Amita, you gave me 10 minutes, so I kind of properly...
Highlighted how the court also needs to look into make the claim holder in center, because you have raised a concern on how the access to justice system is functioning, and we have another speaker who is in fact going to highlight her own model of providing access to justice in land-related cases. So we have Ms. Nupur Sinha.
Well, thank you. Whenever I'm nervous, amidst so much of intellectual talk, I shift to stories, which is what I'm going to do now. When we started talking about implementing FRA, we just did a check. So first thing, of course, was raising awareness and then getting applications made. Now, when the first lot of allotments were done, when we went and had a look, what we realized is that despite the law being very clear that the pattas have to be in the name of husband and wife together, it was not done. Now, this was a very simple thing. We just had to go to the collectors and get letters issued that this is what needs to be done. It's not the difficulty of the action, but it's the fact that something that is so clear still needs to be told. So half of our work is actually about making the government and the judiciary aware of what the latest law is. When PWDVA was passed, the judges did not have translated copies. When FRA came, there was no translated copies available. So that becomes one big part of our work of making people who are responsible for implementation aware of what they are supposed to do. The second thing is that half the time there is work happening, but under what law, under what procedure, under what rule is not clear, and that leads to a lot of unclarity. When we were working on getting women's names updated in land records, we had a lot of struggle because women had to go back several times. And then we filed RTI applications with 7 collectors, saying, can you tell us what is the correct procedure? And on record, we were able to show that there are different procedures that are being followed by different collectors. And we took that to the Revenue Secretary and said, can you please streamline the procedure so that we don't have to run around time and again for simple things like, ye type hona chahiye ki ye handwritten chalega, ye notarized chahiye ki ye simple chalega. You know, that level of unclarity making people run around pillar to post. We are aware of the scheme where government land can be allocated to people who are vulnerable. So we started filing applications under that scheme. And when we went for follow-up action, we were told that there are not enough number of applications, so no land kacheri has been organized. Land kacheri is the process through which these land will be allocated. So then we filed an RTI application saying in the state how many applications are pending. So they said 18,000. So then we filed another application saying, what are you going to do about these 18,000 applications? They said these will be dealt with when the land kacheri is organized. Now what is your next step after this? What do you do? It's like a circle going on and on and on and on and on. One of the first things that becomes very important when you're working on land rights for women is not so much to do with the actual litigation or legal work. It's more to do with creating awareness and changing mindsets. We are very happy, HSA amended, so we started with that as an agenda. After 3 months of work at the field, we realized there's so much resistance to the idea of rights for daughters, but there's so much willingness when it comes to the widows. So we changed our entire strategy and we started looking at widows as our first entry point into the issue, and started identifying widows in the villages and then talking to people about why they should have land in their names, etc., etc. Now, one of the things that we tried to do as part of awareness raising and creating an environment was to target local melas where people in any case assemble. So we had identified several melas where big number of people would be coming, and a lot of stalls and games and awareness programs around that mela. Now, as we were coming back, and our entire communication strategy was focused on widows, because we felt that that is something that evokes sympathy and that is an easy entry. Now, as we were coming back in the bus, there was this group of men who had attended our program in the Mela, and they were discussing amongst themselves कि यार मरने का कौन राह देखेगा, तब तक मतलब पत्नी विधवा हो तब की राह क्यों देखनी है? Let us do it now only. So that is the kind of impact that you can have if you are messaging properly. My concern is that often when we don't segregate who we are going to target, our communication strategies are so generic that it's money spent, but no actual change in mindset that happens. So that is something that becomes very critical. My issue as a single adoptive mother is different from my issue as a hooch widow. And when we don't differentiate that in our awareness programs, then obviously there are no cases and claims that are coming out of those programs. I'll finish much before that. The other thing that becomes, the other story that becomes very important is, there was this process of land acquisition that was, so the Section 4 notice had been served, etc. And people had been struggling for a very long time. So we went there to look at what can be done. And they said, हमने यहाँ पे भी धरना दिया था, वो रैली निकाली थी कल, तब उस कलेक्टर ने ये प्रॉमिस किया था, उस कलेक्टर ने वो प्रॉमिस किया था. I said, okay, fine, but let's look at what do you have in writing. Forget about any promises in writing, even they did not have even the received copy of the applications that they had made. So on paper, practically, there was nothing to prove that there has been a struggle, that there has been an objection, nothing that could show that there has been a struggle there. And that is where the role of paralegals become very, very critical. A lot of action actually does not yield proper result because it's not looking at the use and the possibilities of law at the ground level. In the same Bhavnagar case, what we realized is that people did not have their own land records because nobody bothered to update them, nobody bothered. So overnight land records were changed and we had nothing in our hand to show कि यार ये गलत entry है. There was nothing that we had because we did not have our complete land records in our hand. So that becomes very critical, that how, when you know that this kind of an action is happening, the first thing that you have to do is to at least get your land records, a copy of your own land records, which is difficult to get because people would not want to give it to you. Another story is of a revenue official who was crying. He was otherwise a very, very cooperative person. He was crying. I said, what happened? So he says, there's so much of moisture in the air. All my records are very wet and they will soon get destroyed. So I said, so what can we do about it? So he says, it's very, it's very technical thing and I can't just get somebody to touch my records. Then I said, okay, what can we do? What we realized is that that village was a DLS, a Legal Services Authority village. They had posted a person whose job it is to help people in these kind of affairs. But he does not have the authority or even the information that he can actually sit there and help the Talati organize his records. Now, this is the kind of disconnect that is there between different government programs and different government efforts. When synergized, they can actually do good for the people, but there's no synergy. So there's this person who's appointed, who's paid 250 rupees per sitting, and who's sitting without any work because nobody is approaching him. In that time, he can actually help in updating all the land records, but that is something that is not happening. While working, we realized that forget about women's names being entered in the records. For last 3 generations, land records have not been updated. So unless you do an overall process of updating, how do you get women's names entered into land records? So the process that we did is that, and the basic thing was corruption and one talati looking at 20 villages and therefore not reaching any single village. The basic thing that we did is that we first worked for 4-5 months in creating all the paperwork that is required for that updation, so which include all your Varsanama, PD Nama, all of that. And then we said that on this day in this village, this talati has to remain present. That's the negotiation that we did with the collector. So the talati's job was only to then just enter, and then for that also we had a team of volunteers who would do that. But the practical problem is that if you have one talati looking at 20 villages, even if he's a very good soul, there is no way that he can do what he's expected to do. While we were doing that, we realized that there is a big vacancy that is there for all posts, but definitely for the posts of the talatis. And therefore, what we had to ultimately do is to file a public interest litigation saying, please fill the vacant posts, because without that work cannot happen. Now, the point again is that how many PILs of this nature, of what is supposed to be there already, how much of this, how much of time you're going to be spending into this kind of thing. And actually, practically, appointment of talati in the area where you are filing a public interest litigation for, basically means कि अगर कच्छ में आपने फाइल किया है, तो डांग से उठा करके उसको वहाँ पे पोस्ट किया जा रहा है. There is no new appointments that is taking place. So then when you are starting work in Dang, then you have to go there and do the same PIL. So that's the challenge that you are seeking. The other thing that we tried to do is to look at who are the people who must be aware of the importance of land rights for women. And initially we did a lot of dialogues in our capacities as NGOs, but we said that this has very limited outreach. And therefore, what becomes important is to mainstream this as part of the curriculum. So the administrative training organization, the SPIPA, is where we introduce this as women's land right as a topic in the training for the talatis is something that we introduced. And we could see that these talatis who have this orientation behave differently when it comes to this kind of issue. Now, some other stories. There's this. So this is all the good thing that we have been able to do, but 2 or 3 on what we can't manage. There is this case in Baroda where it was a demolition matter. The locality had 3 types of people who had said, okay, we are fine, send us wherever. There was one set of people who said that we are open to being sent, but not in this location, we want to be sent in some other location. And there was this group of people who said, we will not leave this land. Now, what becomes important is that why is out of 100 slums, why is this particular slum picked up? It is picked up because it has a dargah, which is visited by Muslims and Hindus together. It has mixed community. School children go to schools, to common schools. I mean, to the same school. The Muslim and Hindu children are going to the same schools. And that is something that needs to be broken in the name of development schemes. Now, this is a strategy which is being adapted where people are evicted, and when the allotments are done, they are done of another case of a private nature. Dhakli Pratha, which is bigamy, is quite common, socially accepted, even today, in certain regions. Now, we had this, so as per their tradition, the property is divided into 2 branches. Both the wives get 1 branch. Now, the practice that has been happening post-85 is that earlier the birth registers will say XYZ Kukuna, XYZ Bhil. Post-85, the practice has been on which the tribals have absolutely no say, XYZ Kukuna within bracket Hindu. Now, nobody has ever challenged that. Nobody has ever questioned that. Now, these people are actually Christians who celebrate Bhag Bharat Tehra. They celebrate all their Adivasi customs, their divorces by breaking the stick. All the traditional practices are still there. They go to the church. Their records say they are Hindus. Now the matter came because they said that the second wife's children are not entitled because bigamous marriage, not legitimate marriage, etc., etc. Now, Adivasis who are practicing Christianity, whose names are registered as Hindus in their birth certificate, we actually had to take recourse to Section 16 of the Hindu Marriage Act, much against our own grit, because that says that children will be legitimate even if the marriage is not legitimate. Now the kind of, and this was criticized, there was so much of internal criticism saying you have no coherence. On the one hand, you are saying something else. On the other hand, you are using Section 16 of the Hindu Marriage Act. So aap yahi bol rahe, so we were not able to reconcile it internally, that what does one do in this kind of situation. On the other hand, there is no other option, because what do you do? I mean, so these are the kind of practical challenges that one faces. Thank you.
Thank you, Nupur, for sharing some of the models which you have been using, and you also mentioned how paralegal can be one approach who can work at the community level and empower the community in claiming the right. What we have heard from different panelists, yes, litigation has been used as one strategy for exercising the rights, whether in private property or public property, in public resources, but there are different kinds of barriers, whether it's a group or individual facing, and we heard like some of the issues they are confronting, from non-implementation of law to gaps in law. They also share the procedural hurdles, cost as an issue. They also shared effectiveness of the judges, as well as some of issues which includes some gender aspect which Nupur has mentioned. But what I see in this is like, yes, we have seen litigation can be one approach, but we haven't heard from anyone if mediation is used as for the mitigation in any of these cases. The study has been covering that aspect as well. And also what I have not heard sharing the session, a gender dimension on accessing land. Because coming from Nepal, we fought for years and years for equal right to inheritance. And the court verdict through the PIL helped us to create a right. Now we have equal right in inheritance. But when women got equal right as a widow, as a divorcee, as unmarried, based on the marital status, now government wants to change equal right to inheritance, and now they have a bill introduced in the parliament for will system. And all women came together and they rejected, because see, when you have a woman 33% in parliament, it makes difference. So they rejected the bill. And now, because the argument women brought that only recently we have equal right to inheritance, and then this is time to work for the realization of the right. And we still see a huge gap and resistance among the decision maker, even resistance within the court on realization of the right, and we have not been able to empower women. So if from the floor, we can hear some comment on these issues as well. Now I would like to open the floor. We will take 5 questions first, and then we will give the panelists to respond. Then we will come back again to the floor. So I want to give first hand to, you have to introduce yourself and...
And I think we have built that works to prevent you from accessing your human rights to land. Also, inheritance, of course, a big struggle where you work in inheritance laws, but you're also dealing with landless women. And when you were on a task force for land reform issue, we touched upon that. One of the recommendations in the draft land reform policy was that redistribution must be prioritized to marginalized women, and that never even got into the draft policy. Even though we kept on writing it and sending it, it was left out. So, the kind of patriarchal mindset has to be challenged through human rights education, as Dipur and all are doing, but, it has to be done nationwide. And last very quick point is that, we are seeing a growing trend of this, what the states are using, the language of land banks and land pooling, which is really a euphemism for land grab. And I think we really need to unpackage and deconstruct this as to how land rights are being taken. It is being portrayed as a very voluntary surrender of land, but the farmers, the people who are being made to do this are being coerced. And then again, the non-owners, the agricultural workers, right here, the Amravati experience is really awful. So we can see how dispossession is becoming, getting institutionalized, and I think that's something has to be dealt with at a political level, because land is so political that even the left is not talking about land reform anymore. So I'll stop here. Thank you so much.
So many hands. I'm giving the back. Yeah, from.
I'm Mihir Desai. I'm a lawyer. Yeah. Okay. Only two quick comments. One is that I have not read the study which has been done, but I hope you're talking about the ever-expanding notion of sovereign, eminent domain. I'm sorry, because that's been expanding. The notion of eminent domain has been expanding so fast. For instance, in the Land Acquisition Act, while they can acquire land for companies, for private corporate houses. Okay? And you have a Supreme Court which says that even if land is acquired for private corporate house, it is to be treated as for public interest because it generates employment. Even if I start a pan bidi shop, okay, it will generate employment. So that really, but this is how the courts have been looking at it. By allowing Land Acquisition Act to be used for any and every purpose, which is one thing which I think needs to be focused on. Second thing, I just wanted to quickly talk about what is happening in Maharashtra right now. That in our state, Maharashtra, from which I come, there used to be what were called revenue grants given to devasthans, that is various temples. Now, suddenly the government, the present government of course, much more, is converting those revenue grants into soil grants. So what happens is that earlier you had only right to receive revenue from the temples, had the right to receive revenue from those places, are suddenly becoming owners of those places. So it will lead to a huge amount of displacement. So these are the two comments I wanted to make.
Yeah, thank you. Thanks for excellent presentations. I have two quick comments. The first is all about when we understand the whole revenue system and the land administration, we can very clearly see the trends of the outsourcing of land administration in India. If you look the whole systems of modernization and computerization and digitalization process, there's a great amount of outsourcing is actually already happening. Take just one example, because one of the flagship program of Government of India is a soil health card. Imagine that who is holding the whole database of soil health card? It's Monsanto. So there is such amount of changes is happening very fast. And one of the most problematic area, the whole revenue administration to the larger extent is a non-plan expenditure. So that's how the lower level of officials, they are obviously in the payrolls of the big corporates and the mining companies, etc. So that's a very big issue in the entire framework of land administration. The second issue, I'm very happy that there is a lot of discussion about the land grabbing here in this session. But let me talk about the institutionalized land grabbing. It's not by one person, by one corporate, but by state itself. The Madhya Pradesh, the Central India or Chhattisgarh is a very clear example how the forest department is actually extended their territories and took the common property land and registered in the forest record as a forest land. So take example of protected area, the growing protected area, how they have actually grabbed a huge amount of land from which actually belongs to the indigenous community. So the expansion of the protected area, I mean India perhaps is the only country in the world where the forest area is increasing but the forest cover is decreasing, which is very sad story anyway. We are the petitioner in the Supreme Court. Since 2004 we are fighting on our different capacities. And finally, I mean in the same context, we have also looked at the whole framework of the Forest Rights Act. On the one hand, of course, it's very progressive, very open. They empower the community to go and to register their claim. But what are the performance? And the performance, I think, in my opinion, perhaps one of the main reason is the very dominant character of the forest bureaucracy. So that's how we must to talk about here of the institutionalized framework of the land grabbing too. Thank you.
Can you give the mic here in the first row?
I am getting from several speakers a strong sense of overlap between a number of problems. One is land grab. Two is exploitation of mineral resources perfectly properly, but not without compensation to the previous farmers. And three is communal or common or shared ownership. And I wonder if part of that relationship is due to the chiefs or representatives or big men or whatever of what is nominally, but not really, an egalitarian communal or corporate system colluding with business persons or with state representatives to take this land. Is this really a problem of common ownership, or is it a problem of breakaway big men who are taking action in their own interests to access mineral resources?
My question is for Ms. Bharadwaj. One of the intersections with tribal areas land acquisition for mining and power plants is the intersection with environmental issues. So I wanted to ask you how effective a forum like NGT is because as a part of the question, a very small anecdote. A friend of mine litigates frequently in NGT and managed to get a stay with respect to construction of a power plant in Mirzapur, UP. The basis of that stay was that when the village panchayat and that meeting was organized, in the video there was it was clearly visible that there were some guards who were walking around with pistols in their hands. So quite clearly it was said that the consent couldn't be free then. Right. And then the other fact was that it was a barren land was interpreted as wasteland. And that contention was negated by the court. Now, when the court passed its final order, it said that for now the permission is stayed. And the petitioners who were the power plant owners, they are free to secure another permission if they get these errors rectified. So I don't know how that plays out.
Now what I'll do, I'll take two more questions. Then I'll give to the panel because we don't have enough time. And maybe if anyone has a dying question, they can discuss during the lunch break.
My question is to Sudha Bharadwaj. Ma'am, is there any, because as you have so much of an experience in disseminating the knowledge about land, are you thinking of any kind of a primer to tell people how the law looks at land? Because there is a geographical division of land, there is a scientific division of land, and all that kinds of division is there. When it comes to law, there are 4 or 5 ways or 6 ways, or popular ways: the private land, the government land, and the charais or whatever. So is there any some sort of effort? Because my question comes from Andhra Pradesh effort. Now in colleges and schools, the women question has been brought in very seriously in a form of a book. Some serious debate is happening in schools and colleges about it. Is there any possibility of making some basic primer to tell people about, especially the 10th fail young people, about what does it mean by land administration? The next question is Professor. One. Yeah.
You can ask during the lunch break. Here. Last question.
I'm actually, this is Biju Matthew, and I am probably amongst the least educated on the questions of land here in this hall. And coming out of Sudha, Vasudha and Nupur's presentation, I actually want to ask a question which is, and also Mihir's comment, that is there a way we can distill some of what is being said, especially in the concurrent session, to head towards the question of which are the, let's say, the three most strategic laws, when it legal frameworks, when it comes to the question of collective rights, then which are the, let's say, the most important set of regulatory aspects at district levels, etc. Can we make a kind of a, especially given that the issue of land has dropped out so significantly, can we kind of identify a series of strategic at different levels, legislation, procedures, etc., that we need to find a way to work on to kind of take the challenge forward, kind of trying to bring the issue of land back through a series of strategic thinking about it, that's all.
Thank you. Amita, can we take 5 minutes extra because we started 5 minutes late, and I want panelists to respond within 10 minutes, maybe 2 minutes each. Okay, so anyone can start, like. Yeah, why don't, Nupur start. If you're not ready?
Yeah, I'm not ready.
Okay. So, Vasudha, would you like to take up?
I will respond to this question about primers in colleges and schools. I feel that people are quite literate about what they are entitled to. But the problem is to come to the High Court, to keep knocking at the MRO's office and all that requires so much of energy, so much of expense that you need to have intermediary groups there. Unless you have tribal activist groups or Ambedkar Sangams, things like that, you know. And today we do have those kind of groups. And we need to develop our networks. Much more than the literal facts of the law, I feel that these networks are far more important to access the city and the courts.
Thank you, Vasudha. Now, Sudha, would you like to respond?
Is that better? Okay. Different benches of the NGT have been different. There was a bench what we have observed in the Bhopal bench, many times the NGT is more likely to come down hard on public sector companies and less hard on private sector companies. That is a very common perception. But I'd like to give you a rare case where actually the NGT came down very hard. This was a case filed by Sudeep Srivastav against the Adani mining in Hansdev Aran area, which was earlier a no-go area, classified as a no-go area. And from all the documents which had been produced there, they said very clearly the environment clearance has to be cancelled. And they said that Adani should stop all work. The company should stop all work. First was the cancellation. Second was that the EAC must relook at the question of clearance. And the third was that they should stop all work. Now the company went to the Supreme Court, and the Supreme Court did a very strange thing. It did not deal with point number 1 and point number 2, but it said that we stay the operation of point number 3. So the fact that the company had been prevented from working, that was stayed. So the company continues to work. But the environment clearance which was cancelled has not been, nothing has been done. And the joke of it is, as the company works, the environment gets worse. And whenever you write to the EAC saying, oh, now things are getting worse, the EAC writes back and says, oh, the matter is sub judice in the Supreme Court. So what do we do? Now, so that's a serious question. And the other thing that you said about public hearings, yes, I'm very sorry. Public hearings have become more or less a farce. People do object a lot. But even after all the objection, the clearances all go through. And I think you just see the proportion of clearances going through. It's huge. And this is irrespective of how serious the issues are being raised. We need to do something about that. And I think now the NGT is also under a little bit of cloud, whether actually NGT is going to be allowed to take to be a judicial body, or it will simply become a advisory body. There are plans afoot to remove the NGT altogether. Of course, except where it's useful, like in Jantar Mantar.
Thanks, Sudha. Now, Professor Faizi, if you want to respond, any of the question?
There is no question directed to me, but I just want to comment one thing. One is that the status of the record is in a state that all the records are with, most of the records are with the village level revenue officer, and most of them are of 100 and more than 100 years old. So how it would be? So it is being supplemented by the landowner or the large, you can say the farmer, the bigger farmer. So the poor people have little access to those records. It's one of the problem. The second thing is I want to highlight here is that there are 4 sabhas which is very important. One is Lok Sabha, Raj Sabha, Vidhan Sabha, and then Aam Sabha. And Aam Sabha was very important for survey and settlement, and it is not being held for a long time. So if it is not being held, then the democracy and the rights will not be served. Thank you.
Now, Astha, would you like to respond?
Me? Sort of partially try to respond in the beginning. Just
I just wanted to add on to what Astha did in her presentation to say that the fact of the state citizen litigation, as well as the issues arising there, is very much on board. And that is something which largely through the prism of legislation, as well as the fact that what was happening adjudicatively, we are doing. What she was bringing in as an additional gloss and nuance was that even when you are, like it's not just between the state and citizen, there are lots of places at which the citizen-citizen disputes gets implicated into the state-citizen dispute, and hence it is important to keep both of these in mind. It's important somewhere for us to know that all of these technical things are then employed in various kinds of ways, and consequently your redistribution program doesn't have to just reckon with state legislations, it has also to reckon with the various kinds of private litigations. That was the emphatic point that needed to be, and that connecting point. So Sudha, you're in the right panel.
So I think what we got from Amita Adhanda, the closing remarks, and thank you panelists, and thank you all of you for participating actively.
Do I get one more? Done for the day.